It's time for today's Legal Minute with the Law Office of Cooley, Shrair in Springfield, joined by attorney John Davis. We're talking about discharge in bankruptcy. A lot of people aren't familiar with that phrase. If you wouldn't mind explaining it to us.
Well, a discharge is one of the primary purposes that one files for bankruptcy. And a discharge is a court order by the bankruptcy court that, in essence, eliminates one's personal liability upon certain of their debts. It also prevents the creditors from pursuing that debtor with respect to those various debts that are discharged.
Now, are all of the debts discharged by bankruptcy?
No, they are not. There are certain categories that are not discharged, such as the more common ones are student loans, taxes, divorce-related support obligations, and some cases involving obligations that arise out of fraud or other misconduct.
Let's talk about limitations on the scope of a discharge.
Well, a discharge, remember, only affects debts that are incurred up to the date of the bankruptcy. It doesn't affect debts that are incurred after a bankruptcy. And also, it doesn't eliminate liens, such as mortgages and car loan liens, that stay in place after a bankruptcy, although your underlying liability will be discharged by a bankruptcy.
John, these seem like very complex terms and times. What would you recommend for someone who's going through something like this right about now?
Well, bankruptcy is complicated, and for that reason, I always recommend that you speak to a qualified attorney or other qualified expert to deal with these sorts of matters.
And they could do that with you and the other folks at Cooley Shrair. It's a pleasure chatting with you today. That's your Legal Minute, and for more information, call 413-781-0750, or you can visit them online, cooleyshrair.com.